Distinguished guests, ladies and gentlemen, a very good evening to all of you. On behalf of Blue One Inc., I extend a warm welcome on this wonderful occasion. We are gathered here to release a unique book, March to Justice Global Military Law Landmarks, edited by Major Navdeep Singh and Colonel Franklin Rosenblatt. Blue One Inc. is extremely proud to have published this anthology featuring 25 renowned international writers, probably the first of its kind on military law. We have in our midst a host of luminaries from law, the military, and other fields, and it is my privilege to present them to you. General V P Malik needs no introduction. As a former Chief of the Army Staff who led us to victory in Kargil, he retired at the turn of the century and has remained active in military and public affairs. He has written books, authored many well received opinion pieces, and the intelligentsia values his thoughts on military, strategy, and geopolitics. We are fortunate to have him here, and he has made it despite a very hectic schedule this week. Welcome, sir. Justice Rajiv Bhalla retired as a judge of the Punjab and Haryana High Court and has spent more than 40 years in the legal and judicial fields. He was the chairperson of the Punjab Educational Tribunal and the Rera Appellate Tribunal after retiring as a judge of the High Court. Having delivered lectures in multiple universities and academies on legal subjects, he has a high degree of command over civil and constitutional subjects. Welcome, sir. Major General Neeraj Bali has served for 37 years in the Army and has been decorated with the Gallantry Award. General Bali is also the founder CEO of Leadscape Advisors, a consultancy for corporate training and transforming organizational culture. He is a teaching faculty of the Institute of Competitive Intelligence, Germany. He has also delivered talks on leadership, disruption, and competitive intelligence at several prestigious forums all over the world. Welcome, sir. I would now like to introduce the editors of March to Justice. Major Navdeep Singh is a practicing lawyer at the Punjab and Haryana High Court and was also the founder president of the Armed Forces Tribunal Bar Association. He has been a part of high-level committee constituted by the Defense Minister to reduce litigation initiated by the Ministry of Defense. He specializes in constitutional law and service matters and is a strong votary of judicial independence. Welcome, sir. Colonel Franklin D. Rosenblatt teaches at the Mississippi College School of Law and is also a judge at the Military Court of Appeals at Mississippi. He is a highly decorated former officer of the JAG Corps of the U.S. Army. Welcome, sir. I would now like to introduce our panelists for today's discussion. They are all contributors to the book, and most of them are joining us virtually. Professor Eugene R. Fidel has taught at Yale Law School and NYU Law School. He is also the President Emeritus at the U.S. National Institute of Military Justice. He has authored several books and is known as the Dean of Global Military Justice Reform in military circles. Welcome, sir.
And if I could intervene, please. Gene is trying to get onto this forum, but he's getting a message that it's already full and he can't join. So if somebody could help him, please.
I think we'll take care of that. Justice Maria Elizabeth Rocha is a sitting judge of the Superior Court of Brazil. She is a part of several landmark decisions related to the military and is also a constitutional law and military law professor. Welcome, ma'am. Professor Shriti Bedi teaches law at the University Institute of Legal Studies at Punjab University, Chandigarh. She has authored 2 books and co-edited 4, besides many articles in reputed publications. She has also lectured at various international and national forums. Welcome, ma'am. Judge Maya Heller has served as a judge in the Israel Defense Forces Military Court of Appeals. She held the rank of colonel in the Israeli Defense Forces and holds a master's in law with distinction from Tel Aviv University. Welcome, ma'am. Dr. Pascal Levesque is a former legal officer of the Canadian Armed Forces. He has also taught law at the Royal Military College of Canada. As a lawyer, he has appeared at all levels of courts in Canada, including the Supreme Court. He currently works in the sphere of parliamentary ethics. Welcome, sir. I would now request General Malik to do the honors of releasing the book. Thank you, sirs. I would like to request General Malik to please speak a few words about the book.
Justice Bhalla, General Bali, the editors Major Navdeep Singh and Mr. Franklin Rosenfeld, ladies and gentlemen. Firstly, I must say thank you to Navdeep for, ladies and gentlemen. Firstly, I must say thank you to Navdeep for, I think, yeah, I must say thank you to Navdeep. Let me first say a few words about Navdeep, the author, as far as this book is concerned, the editor. He's, of course, the foremost military lawyer in our country. And I would consider him to be the most passionate as well as compassionate military lawyer. His passion has been to fight for the rights of the military people, the retired people, their kith and kin. The number of cases that he has fought is amazing, and today probably he is the authority. Everybody likes to go to him if they have any dispute. And he has those two books that he has written earlier, Maimed by the System. They indicate both compassion as well as his passion on that subject. So my compliments once again, Navdeep, for the excellent work, and I feel privileged to be releasing this book also. My compliments. Now, this book, I will give you a little introduction from the point of view of military justice. The purpose of our military justice is to ensure that we can maintain discipline, we can maintain efficiency, and we can maintain morale in the armed forces. Because if justice is not done, in fact, the very first thing that we learned as young officers was that you have to be very fair. When you are commanding the men, the foremost thing that was taught to us is that you have to be fair. And fair meant almost every aspect of our social life in the military. And so when one is considering this military justice in the army or armed forces, there are two aspects. One, I said, is fair play and justice must be done and seen to be done. Also, these cannot be sacrificed as the altar of discipline. You can't say because of discipline or because of tradition, and therefore, you can deviate from justice. We have a number of cases. Some people get biased because of their traditions and because of their regimental spirit and things of this nature. And an unjust decision is subversive to military discipline. That's what I feel. The other aspect is judicial independence, which cannot be disregarded in our system. Unfortunately, I wouldn't call it still 100% correct as far as the armed forces are concerned. There are certain areas which need to be improved, because it is absolutely essential that judicial decisions must not be influenced by any external or personal interests. Judges and prosecutors, now this word both are judges and prosecutors, should be free from external interference. We still do not have the prosecutors being free from our, is that right?
Yes,
You know so much about it. And there are many aspects which still need improving. Earlier, when we had the Armed Forces Tribunal, they were put as part of, for administrative purposes, they were put part of the Ministry of Defense. Now, that was a big lacuna. I believe now it is being corrected thanks to his challenging in the courts. So, like our national laws and legal system, we all understand that military justice has also to adapt to legal, military, and social changes taking place in the. Over the years, there are many social changes taking place, and those have to be considered. You can't go keep on harking on the old things. So, this book, March to Justice, I've read now, is an anthology of judicial pronouncements and many milestone decisions which have impacted military justice in different parts of the world. I would call it that our military law, thanks to Navdeep, has now been globalized for good, because now we are learning of the military justice practices and the way it is being done in other parts of the world also, thanks to the authors who have written these essays and they have given there, and the judicial decisions which have been taken in this. So I have read the book. I think it's a very fine book, and I'm sure it is going to do much good to our own military justice system that we have in the armed forces. And for that, I must once again congratulate you, Navdeep, and also his co-author, co-editor, Franklin Rosenfeld. Thank you very much, ladies and gentlemen.
Thank you, General Malik. I would now like to request our moderators to take over and proceed with the panel discussion.
thank you, and thank you, General Malik, for those words about the book. When this book was sent to me, I was a little skeptical upon the contents, because normally people with background in a particular chapter which is dear to them from the book, because I think no book launch is complete without a little bit of the reading of the book. So please bear with us for a little while, and I'll request Navdeep or Frank or both of you to do the honors.
Thank you, sir. We'll both do it, sir, and we'll be very brief. So I've chosen a few passages because General Malik has very rightly pointed out the lack of independence in the military justice system as on date. It's not by design, I would say, but only that we have not progressed well and in tune with the other global systems and other facets of global justice reform. So the lack of prosecutorial authority, the independence of prosecution. We don't even have a director of prosecution as of now. So I'll just, interestingly, I got many messages from young JAG officers saying that they liked what Justice Bhalla and I had discussed with General Bali on an online show a few days back. So I'll just repeat a few lines from the book related to that, which directly deals with JAG officers, and then I'll go on to read a few lines by Judge Maya Heller's chapter. She conducted a case. She was a judge in a case called the Lower Azaria trial, wherein an Israeli soldier was accused of shooting at a terrorist who was already down and injured. And that soldier killed him, and there was a lot of national passion in Israel, with people calling him a hero, including the politicians in Israel and including the military hierarchy. And they wanted him saved and they wanted him acquitted. But kudos to the judicial system in Israel, that Judge Maya Heller, who was still wearing the uniform of the Israeli Defense Forces, they withstood all that pressure and they ultimately convicted him of manslaughter. So I'll just read a few lines also from her chapter. I'll be very brief. From my overview, I'll read out. It is therefore of great concern that what to talk of prosecutorial independence, the value of which was realized more than a century ago, the concept of independence remains hazy even to members of courts martial who are not even legally qualified, and all other nuts and bolts of the justice dispensation system from top to bottom. We need to work on this, and we really do. We also need to work on correcting the situation where our officers get personally enmeshed with litigation, making legal processes a prestige issue, rather than following the ideally expected behavior as the representatives of a faceless government concerned with justice and not with winning or losing. So this I say because I find many of our young military officers, especially of the JAG branch, getting very personal with litigation, as if, it's a prestige issue that we have to win this case by hook or crook. It should not be like that. The aim has to be to assist any court or any forum in arriving at justice. That is the aim, even in an adversarial system. The pressure on officers performing these roles must be eased. The message must not go out that one has to win by hook or crook. Justice is nobody's personal property. Justice belongs to us all, to both sides in the judicial process, even in an adversarial system. While penning this, I'm reminded of Justice Robert H. Jackson's, he was a judge of the Supreme Court of the US, his famous words, which are, although the government technically loses its case, it has really won if justice has been done. So even when the government is losing, the government is actually winning because justice is being done. So it's very scary at times when the government itself is not personally involved in litigation. It does not want to win a case, or it also wants to assist in arriving at justice, but still officers at the lower levels get so much personally involved in cases that, trying to create a total fear psychosis that as if heavens are going to fall if we lose a case. In fact, the system of justice is that let justice be done even if heavens fall. I'm sure people would be aware of this Latin maxim. I think it was first used by Lord Mansfield in the 18th century in the very famous case Somerset versus Stewart. Is anybody aware of that? That was the case which started the system of abolition of slavery in the United Kingdom. It was ultimately abolished, I think, in 1807. So in that, Lord Mansfield said that justice be done even if heavens fall, saying that we are not. So therein the government was saying that if we abolish slavery, there'll be lack of manpower, this, that, the army would require manpower, the civil services would require manpower, the economy will go down. But Justice Mansfield said that justice be done even if heavens fall. Whatever be the consequences, a judge or the legal system or even the lawyers are concerned only with justice. We are not concerned with what's happening outside the courtroom and what are the consequences. And as General Malik rightly said, the idea is absolutely to ensure justice. And in a military backdrop, being fair and being just will in fact encourage discipline. It will propel discipline to a better stage. And fairness is always, these are intertwined. Discipline and morale and justice are intertwined. Justice will lead to bettering of discipline and not the opposite. Now I'll read what Judge Maya Heller has stated in a chapter in the Elor Azaria's story, I would say. This is what she says in her judgment. Judge Maya Heller is here. She'll be speaking later. Given the above, we have found it appropriate to already clarify now that the ruling in the defendant's case is based solely and exclusively on the evidence that was presented and heard within the court's walls. So whatever is to be done within the courtroom, not outside it. Whatever is happening outside is not the concern of a lawyer or a judge. Since a judge has only what his eyes see, He is guided by his judicial discretion and the command of his conscience. This is the essence of the principle of the judicial system's independence. Its integrity and its power derive therefrom. And it has already been held. The presumption is that the courts will stand firm and will not consider anything other than the evidence before them. This is the judge's test. This is the heart and soul of the judicial system. Then, on the aspect wherein in Israel there was a whole lot of public debate and military officers, senior military officers making comments in favor of the Israeli soldier who was later convicted, and even politicians making statement in his favor. She says in the judgment, indeed, while sitting as judges, the judges are not subject to any authority other than the authority of law, and yet remarks that are voiced by senior public figures have a very broad impact on the public's position and on the public's trust in the judicial authority. Respecting the principle of separation of powers thus requires expressing oneself with restraint and caution with respect to matters that are pending in court, and breaching this duty would severely harm the principles underlying the democratic regime in the state of Israel. She's talking of the state of Israel, but it's valid for any democracy which is characterized by the rule of law. Criticism of this kind, directed at the Minister of Defense and the Chief of General Staff and public electees, the most senior thereof included in the judgment itself, also reflects the nature and character of our legal system, which rests on a solid foundation of judicial independence and which allows and even demands, when required, that truth be spoken without reservation or qualification. Also, this too must be said. In my opinion, a strong army is an army that can easily absorb such criticism, as is the case before us. These are the words of Judge Maya Heller. Maybe Frank can now read something.
Hi, everyone. Frank Rosenblatt here from Jackson, Mississippi in the United States. In the 3 years that Navdeep and I have been collaborating across hemispheres on this, we've learned a lot. We think that military law, in a number of surprising ways, is a very effective way to diagnose the health of a democracy. You take a look at the rights of soldiers. Do you lose all of your rights when our sons and daughters join military service? And the part I'm going to read from is from an essay from General Jan Peter Spijk, who wrote about the Engel case versus the Netherlands from 1976 before the European Court of Human Rights. This gives a succinct answer to that question, and that many of our essayists have largely touched on these parts. The court writes, each state is competent to organize its own system of military discipline and enjoys in the matter a certain margin of appreciation. The bounds that Article 5 of the European Court of Human Rights, in this case, requires the state not to exceed are not identical for service members and civilians. A disciplinary penalty or measure which on analysis would unquestionably be deemed a deprivation of liberty, were it to be applied to a civilian, may not possess this characteristic when imposed upon a serviceman. Nevertheless, such penalty or measure does not escape the terms of Article 5 when it takes the form of restrictions that clearly deviate from the normal conditions of life within the armed forces. In order to establish whether this is so, account must be taken of a wide range of factors, such as the nature, duration, effects, and manner of execution of the penalty or measure in question. Thank you.
I'll take it from here and do a little, though the book, everybody's spoken about the book, but a little bit about the book. I'll just take 2 minutes. There are chapters from Nepal, starting from Nepal to Colombia to Brazil. There are chapters from England, from UK, from the USA, from almost every country in the world, India, of course. And there's one thing we've got to remember, that the Indian Army works under the Constitution of India. But unfortunately, the rights that you and I enjoy as civilians are not available to the Army because of Article 33 of the Constitution. So if anybody's a little intellectually inclined, please go and read Article 35, how it impinges the rights of people in the army. And therefore, when we talk of military justice, we must keep all that in mind, that an army officer almost acts with his, let me say, his arms tied behind his back. That's one aspect. Of course, there's the other aspect of justice and morale, and everything is there. But it's a very fine balance which everybody walks. It's not as if everything will be sunk if we do justice, but then eventually we are going to take this forward, and General Bali will read out the message of the UN Special Rapporteur, which we have in this book. And that also, I'm requesting all of you, anybody who wants to pick up this book, please go through that. That's something very enlightening. General Bali, your take now.
Thank you, Justice Bala. So I suspect that the next 1 hour is going to be a little bit serious, as it must be. So I'm going to introduce a note of lightheartedness right in the beginning. Speaking of military justice, the funny man Groucho Marx had said, military justice is to justice what military music is to music. Now, as a soldier, I cannot subscribe to that view. But if you read the fine print, it does say that perhaps there are infirmities, some challenges which are there in every system, which as the former Chief of Staff said, would be in ours too. And this is reflected in what I'm about to read. I'm just going to read 3 or 4 sentences. This is the foreword by Diego Garcia Sayan, who's the United Nations Special Rapporteur on the independence of judges and lawyers. And he says, although unique on its rules, the military justice system should be recognized as a full partner in administering justice for certain matters within its competence alongside the ordinary civilian justice system. Therefore, the principle of judicial independence should be a parameter to assess and study the functioning of military courts too. He goes on to say that ideally a truly independent judiciary should possess at least 3 features. Firstly, it should be impartial. Second, judicial decisions should not be influenced by any external or personal interest, as Navdeep just brought out about the Elo Razaria case. And finally, judges and prosecutors should be free from all interference. This central theme of independence is what rings through this book as you go chapter after chapter. 2 more sentences. He says, as this book indicates, the purpose of military justice has been to ensure that military leadership can maintain discipline, efficiency, and morale. And this again you will hear many times in the evening today. Also, as several contributors describe in this relevant book, just as the civilian criminal justice system grows and evolves in response to developments in law and society, so does military justice, or so should military justice. We cannot disregard the application of the principle of judicial independence in the operation of military courts. And therefore, this becomes relevant to encourage further discussion on the intersection and application of the principles of judicial independence from the military perspective. In other words, there are challenges, there are things to be sorted out in global military justice systems. This book is a fine platform from where to take off and begin. And status quo is not a luxury we have or we should have. And my favorite quote about status quo is that some people love status quo long after quo has lost all status. Hopefully, all the people sitting here and certainly the people who wrote these books don't believe in that. And they will go forward and tell us much more about it. And thank you.
We would now, the 2 of us, that's General Bali and me, we are actually here as moderators, but we are also doubling up as like floor managers. So we'll take it from here. We have amongst us probably a gentleman, not here but online, who's known as the father of military justice reform, Professor Feidel. I just request him to, if we can just enhance his picture a little. Professor Feidel, are you there?
I am. Good evening. Good morning. Good evening.
Good evening. It's evening here, but it's probably morning there.
It is.
So I'm the one who's going to be asking you a few questions. And was I right in saying that you're father of military reform?
Not guilty.
Legitimate or illegitimate? That's the question.
Well, first of all, I'd like to give credit to Major Navdeep Singh and Colonel Frank Rosenblatt, as well as the organizers of this program. Frank and Navdeep have done a fabulous job putting this book together. It's important on several levels. Number one, it's the kind of leadership that lawyers and military officers have to demonstrate, and they've demonstrated it terrifically. Second, I think their effort to bring together stories of cases. I'm thinking of Judge Heller's essay on the case of Sergeant Elor Azaria as an illustration. It is tremendously important, both for scholars in the area, but also for practitioners and law students. One of the things that I love when getting together with other lawyers is to ask, is when people start a paragraph by saying, "I once had a case," and you never know what they're going to say. We've all had that experience, and it's what makes our profession so rewarding. And that reward is available in such great richness in the field of military justice.
So my question to you, I'm coming straight to my question. We are a little hard pressed for time, and then we'll have an audience which will eventually start walking out. So we don't want to, we want to keep them riveted with you. And the question is, in your little chapter which you've written, you've talked about something called service connection, service nexus text, and then refer to 3 American judgments. And you also write about your disappointment with American Congress, and you used a word which I'd like you to use and explain in almost in the opening paragraph of your chapter. So could you just take it? It's a little convoluted, the question. It's got 3 questions in one, but I think it's better to go that way. Otherwise, we'll end up sitting here all evening. So please, it's all yours now.
And your precise question is what?
My precise question is, can you just explain the service connection and service nexus text? And then you used a word that you're very disappointed with the American Congress for what it's doing to military justice. And the third question is that you used the word, the dark side of American exceptionism. So what exactly are you trying to convey?
Well, on the dark side of American exceptionalism, it's an unfortunate fact that our national narrative is that there's something special about us. And, probably every country makes such a claim. Every democratic country, at least, makes that claim. Whereas one would think we would all be a lot better off if we were simply just another country trying to do its best, both with respect to the administration of justice and the armed forces, and with respect to the administration of justice generally. Now, with regard to the role of Congress, a brief note: Congress, under our Constitution, has power to pass laws for the government and regulation of the land and naval forces. That's the text of the Constitution. And Congress does that by enacting a statute called the Uniform Code of Military Justice, which applies to all branches of the service. But its role is heavily influenced by input from the Department of Defense, and a case can be made that Congress is, in important respects, dependent on the Defense Department for information, for guidance, and that it's too deferential to the Pentagon in making decisions. And we've had a recent illustration of that in the legislation that is now on President Biden's desk, the National Defense Authorization Act for fiscal 22, which makes major changes in the military justice system, particularly with regard to who has the power to charge an offense. And that was heavily influenced by the Pentagon. There were many people in Congress who were quite interested in going further than Congress ultimately did. It's a case study that the political scientists are going to have a field day with. I think I'll hold it there. We may return to it later in the discussion. And your first question had to do with service connection. The question of the limits of the subject matter jurisdiction of courts martial is one that every country that has a military justice system faces. Is it going to be wide open as it currently is in the United States, or is the aperture going to be smaller? Are we going to slice off offenses like murder, manslaughter, rape, and so forth, particularly if committed in the country rather than on deployment? Are we going to insist that there be some factual connection rather than a theoretical or a sort of aspirational connection between military service and the offense committed? Suppose it's simply a robbery downtown, outside the installation. What business is that of the military justice system? This was a subject that the U.S. Supreme Court addressed in the great case of O'Callaghan against Parker. And the court there said there has to be a substantial military connection for off-base offenses, for any offense, actually. And one of the factors would be where did it occur? Was there a military instrumentality used? Who was the victim? And things along that line. And why is this important? Because in a military court in the United States and in other countries as well, I'm thinking of Canada, there are certain rights that a soldier does not have. In our country, it involves the grand jury. Many countries have given up on grand juries. It may involve the right to a 12-person jury. It may involve the right to a unanimous jury. It may involve the right to have a judge deciding the case who has a substantial term of office rather than serving at will. Tragically, the Supreme Court, in the case of Solorio against the United States about 18 years later, overturned its own prior decision, as it can do. And we went back to the allegedly historical pattern that it was anything goes in terms of subject matter jurisdiction. Congress could change this because Congress is not compelled to exercise its full constitutional power. But Congress has shown no interest whatever in pulling back the scope of military subject matter jurisdiction. So I think I've put a bunch of things on the table there. Suppose I stop there so that other people can get their oar in.
Thank you for those replies. But I will promise you we'll get back to you a little later in the session. Now we have with us Justice Maria Osha, all the way from Brazil, and just because of the internet, that we can ask her these questions that she's here. I welcome you to this session. Could we have you on the good evening? Is it evening, morning, night? We're not too sure.
Morning. It's morning.
So good morning to you, and welcome to this session.
Thank you.
I've read your article or your essay, and Brazil had a long tradition of the military sitting in parliament itself or running parliament.
Yes.
So how do you think that still continues, or how do you think military justice system has been able to get rid of that background?
I see. Well, first of all, good afternoon, ladies and gentlemen, and I would like to thank Major Navdip for the invitation and congratulate him and Professor Franklin Rosenblatt for editing such important book, March to Justice. Indeed, it is a relevant work which will increase the bibliography about the team. And my compliments to all authorities and professors in this panel, in particular to my friend, Professor Eugene Fidel. It's a pleasure to be here. Well, in Brazil, we have a lot of challenges about military justice. And the first challenge is face in overcoming the stigma of corporative justice. Well, the statistics reveal the severity of its enforcement, not admitting the impunity of the accused when the responsibility and the offense are effectively proven. The military justice is bicentennial. It's the oldest justice in my country, but society and more gravely, law operators know so little about its competence and performance. It's common to label it as a tribunal submit to political regime, especially under dictatorships experienced in Brazil on the past, and nothing is further from the truth. The court registers memorable rulings during this period supporting liberties and human rights. And furthermore, it's important to emphasize that military justice in Brazil practically complies with all the principles established by the United Nations for the military jurisdictions in the world. The only exception is to try civilians. It was instituted by the federal constitution and regulated by law, being incorporated into the judicial power structure since the Brazilian Constitution of 1934. All the judgments observe the due process of law, which is indeed a constitutional requirement. In peace times and war times, it applies international treaties, especially the humanitarian treaties and Geneva Convention relative to the treatment of prisoners of war. The under 18 individuals are not tried nor prosecuted, respecting Beijing rules and the Statute of Child and Adolescent into force in the Brazilian juridical system since 1999. The military penal code does not exempt an individual from responsibility for crimes resulting in violations of human rights, genocide, or crimes against humanity when he invokes the legal duty to obey. And Brazil is signatory to the Roman Statute, and the state is submitted to international penal courts. All decisions, our decisions, can be brought to the Supreme Court review. The hearings and trials are public, and the judicial decisions founded. The magistrates and public attorneys are civil servants who enter the career through the diploma contest, and all are completely independent. And so, what can I say in brief words is that military justice in Brazil, because we have two state members, justice and federal justice, because we are federation, they both observe all the democratic principles imposed by rule of law.
Can I ask you another question?
Sure.
Your article is primarily based on the right of an accused brought before the military tribunal or the investigation to remain silent.
Yes.
Can you just explain that? How did that eventually develop or evolve in the Brazilian jurisprudence, military jurisprudence?
Yes, and I apologize for my English because my English is not very good. But
no, I think it's perfect. We've all understood you.
No,
it's better than most of us.
No, not at all, not at all. It's not my first language, so I have some difficulties to express myself. But this this guarantee is included in our Constitution, Article 5, and our justice didn't observe it. So I quarrel with them because I am a civilian judge at the military court. I was a lawyer before. I am a former lawyer, and I struggle a lot with this guarantee because sometimes our defendants were listened in the condition of testimony, and after they were indicted after this hearing. So the Supreme Court, after a lot of, I can say a lot of rules that change our jurisprudence, and now we are obliged, to give this right to remain silent to all of persons which were listed in our jurisdiction. I don't know if I express myself.
I'll just add a little bit of there. The system is slightly different from what we have. It's
I
an
will.
inquisitorial system where you have to prove that you are not guilty. So
Oh no,
over there also, the right to silence is now available.
no. In Brazil, no, the public attorney must prove that you are guilty, and the defendant has the presumption of innocence.
But you've written somewhere that there's an inquisitorial system in
Yes,
force.
yes.
I think that's where the connection is snapping a little.
Yeah.
So anyway, thank you very much.
Thank
And
you.
we'll get back to you during the discussion. Now, my next guest or contributor to this thing is something who I think all of us know very well. She's Dr. Shriti Bedi, local of this city and a local of our university. And she's not only, this is not her first contribution, she's written a host of books. I think probably she'll fill half this room with all her books and her papers. So Shruti, a small question to you, because since you are from India and you've written something in this, and with a little play on your name also. So from Bedi to AFT, 25 years, how do you look at it? Bedi is the famous PPS Bedi case, which actually led to the creation of the AFT, and that was almost 25 years. So how do you look at that journey, or is it still far off, or are we riding into a sunset, or is it a sunrise? And there must be some members of the AFT here. We'll request them also to join a little later. Yes, Shruti, your job.
Thank you, Justice Balla. Even though the name of the case is a namesake, but I have not written on that case, but I would like to comment on it. And I would like to take a cue from Major General Bali's reference to the military music. There was a British professor who criticized the Indian Constitution that it has the tone of a military band gone wrong. And of course, we went on to prove that the Indian Constitution was not what he said. So,
like we always do.
No, it is a fact. And the Indian Constitution, which I think you have referred to, and Major Navdeep has also spoken of, including Major General Bali, all giving reference to the fact that we refer to the Constitution because of the principles of natural justice. The two principles of natural justice being that you have a right to be heard, from the Latin maxim audio alterum partem, and the second one, which I think all of us are referring to, which is an impartial hearing and to be heard without bias. And I think that was the significant point in the Colonel PPS Bedi case, which was brought to light, where it was pointed out by the Supreme Court, a bench of three judges, which said that when you go and appeal, you cannot appeal from Caesar to Caesar's wife, because that will not give you a judicious appeal. And it is here that we really look at what the Armed Forces Tribunal is doing today. There are members in the AFT, if I may be permitted to say so, and I think everyone is aware that there is a judicial member, but there is also a member from the retired or the superannuated armed forces. And it is here that this point really becomes relevant, that is the judicial review which is being provided today, which was referred to in the PPS Bedi case as a point of or a bone of contention. Are we really, have we moved beyond that, even though we have a tribunal which looks at judicial review? But is it really impartial, and is it really fair to the soldier, to the sailor, and to our airmen who are serving the country? And that is the question which I wanted to raise here as well, that even though the factual canvas of a judicial review has been provided through, after 27 years of the Colonel PPS Bedi case, through the Armed Forces Tribunal, but in reality, have we really come to the fact which we see in the other countries like USA, like UK? Uh, we need to really provide for an impartial tribunal. Second point, which was already raised by uh, General Malik, was that Major Navdeep had argued the case wanting the movement of the Armed Forces Tribunal out of the purview of the Ministry of Defense to the Ministry of Law. And although the appeal went to the Supreme Court, Apex Court, but there is no further, I think, development on that. And that is
No,
the.
actually, our High Court ruled that the AFT should come under the Ministry of Law and Justice and not the Ministry of Defense. I was the petitioner actually. Mr. Amit Narang was the counsel. He's here. So the High Court ordered that the AFT will come under Ministry of Law and Justice and not under the Ministry of Defense. The government filed an appeal, but there was no stay by the Honorable Supreme Court. Supreme Court said that we'll only stay the contempt proceedings, but you implement the judgment. But it has still not been implemented. But as you know, the Madras Bar Association, the same thing has been now ordered, and a national tribunal commission. Now they've said that all tribunals should go out of the ministries against which they have to pass orders, and they'll all come under the National Tribunal Commission. So that.
So I think we are moving ahead,
Yes,
but I hope we can reach where we really need to be.
Absolutely.
Shruti, now the next question. You've written a chapter called Remaining Faithful to the Demands of Legality in the Face of a Violent Crisis. And you've written Manipur Encounters. I think this is something very raw right now in all our memories that's just happened. So can you little amplify on what you've written and what was your experience? And I believe your thesis was also on cross-border terrorism at one, you've written one. So please,
Right, sir.
put the two things together in perspective for the audience.
I think AFSPA has been a bone of contention for many people, and it is indeed extremely unfortunate and heartbreaking for the people who have lost family members. But on the other hand, we have a situation of insurgency where there is a constant threat to public order, where our soldiers are put in a situation where they have to constantly ensure that the citizens of this country are secure. And while writing the commentary on the Manipur Encounters case, what I really thought of, and which was probably highlighted through the research, was the fact that, the armed forces are actually supposed to defend our borders. But when you are put in a situation like the Manipur under the Armed Forces Special Powers Act, you are actually fighting your own citizens, your own countrymen, and that is not what they are trained to do. And they have therefore to decide, on the one hand, you're trained to fire at the enemy, and any hesitation means that you can be, it's a criminal offense if you do not take down the enemy. And in a situation of insurgency where you are trying to seek a clarification in a moment's time, that is it a normal citizen, or is it a terrorist or a militant or an insurgent, the decision which has to be made in a split second really decides his fate. And that is why the AFSPA was actually, AFSPA does not create a new offense. it gives a defense to the soldier who has taken that decision in that moment, uh, a moment where he could have decided not to take action and probably lost the opportunity to kill a dreaded terrorist or a militant, or has committed a huge blunder by taking the life of his own countrymen.
So a small supplementary to this question, and which actually we can open it up when we come to the stage of discussion, that where would the protection provided by this act end, or where would the prosecution for an offense begin? So that, I think, is also part of your
So
essay.
I think the 2016 judgment
is there,
by the Supreme
but
Court.
still it's not being followed or understood or implemented. So,
So
can
the
you just please explain what is the test eventually?
So,
Because we have a mix of civil and army over here. So some army people.
So
will
there
have a
is no
particular
blanket immunity for the soldier. And there are two conditions which really have to determine his conduct, which will be analyzed before before the judicial tribunal. And his act must have been committed only in the line of his official duty. So that is the number one point. And number two is that it should have been in good faith. So these are the two parameters which AFSPA itself recommends to test whether or not the soldier is right and should he be punished. Therefore,
good faith, with due respect to what you are saying and what the Supreme Court has also said. Now, good faith is a word that can be twisted either way. Like, let me say, like almost anything in law. So, where will the boundary? Where will the boundary lie? I'm not asking you for a judgment.
that's your prerogative, I think.
No. I'm just asking everybody to consider. We are all people who understand life, who understand what the army is, who understand what is terrorism. Some of us in Punjab have witnessed it personally at a time. Some of us have people in the army. Some of us have witnessed people who have been killed in such encounters. So please do not make these value judgments which are just made across the board. So a small request that it's a gray area which will be done from case to case. Sometimes they'll go in favor of the army and you'll criticize the army. Sometimes they'll go in favor of the person and you'll criticize the other person. So this is an area, good faith. Now, what is good faith? That's what will be determined. Is that right? I'm sorry. I hope I haven't taken up your time.
Not at all, sir. Good faith, I think, again, sir, will depend on the facts and circumstances of that situation, which must be brought forth through the evidence and the collective situation. Thank you.
Okay, I think now I'll request General Bali to take over and take the proceedings forward.
Not very much like what soldiers do. They stick to the straight and the narrow. I'm going to veer off a little, and instead of going to Judge Maya Heller, I'm going to request General V P Malik to talk about this Armed Forces Special Powers Act and what are his views on what has just been said.
Thank you, Neeraj. Let me first say that this recent incident that took place in Nagaland, in Mon district, was rather unfortunate, and in which so many innocent people got killed. And it happened, unfortunately, people who were involved in it from 21 para special forces who have been doing exceedingly well in their professional duties earlier. Now, AFSPA, when it was made into a law, at that time, Mr. Pant was the Home Minister when it was passed through the Parliament. And during that period, he had said himself that this law should not be kept at a place for longer period. It should be there provided for short periods only. And that was one of his conditions when he was getting the bill passed. And he had also realized that it is only for short duration and it is only meant for certain contingencies which occur, which is, when you have the disturbed areas. Now, all over the world in democratic countries, but let me say that for a very long time in such incidents or such situations in Northeast, Nagaland, Manipur, even in Punjab, and of course in J&K, all places and all. Let me first clarify. Some media people have been in the recent, after this incident, they've been talking about armed forces, or particularly army, in a very derogatory term, as if we've done it deliberately and intentional. I think there can be nothing farther than that. The kind of writing that have come up, it has really hurt me, a retired soldier for last 20 years, and who have gone through these experiences personally. That anybody does such acts deliberately. There may be a few aberrations and all. Let us not forget that the army training is, in our scriptures, we know what happened in Mahabharata, or what happened in, or even Guru Gobind Singh said, De Shiva Var Mohe Shubh Karman Ko, when he's talking about this. So this is something which is ingrained in our training all the way. And my first commanding officer, the teaching that he gave me was, I was adjutant in the battalion, and when he called a person who was accused of something, so all he said to him was, Banda ban. And I'm from Sikh battalion. He says, Banda ban. And rest of it was in his eyes, the gussa that he had. So that is the way we have brought that. Look, you cannot do something, you cannot violate your human rights, etc. Now, as far as AFSPA is concerned, it has been under discussion for such a long time. I had also gone and spoken to the Jeevan Reddy Commission when it was constituted some years ago. Firstly, I don't think we can blame the law. It is for the situation for which this law was enacted. You don't have a disturbed area, you don't need to exercise this law. And why are we continuing with this? I'll give you a story, personal story. I was commanding 8th Mountain Div in Nagaland, and one candidate for chief ministership in Manipur, he had been during his election campaign saying that he will have AFSPA removed because it is not to the liking of the people. And he kept on campaigning on that basis, and he won the elections. So when he won the elections, I went and spoke to him. I said, sir, you have now become the chief minister. May I know what is your view on AFSPA? So he said, well, this law has to be removed. And therefore, I'm going to ask the government of India that fair, after all, both the state and the center, they have to declare it as a disturbed area. You don't declare it as a disturbed area, and you don't need the armed forces for that. So I told him, I said, sir, fine, no problem. Please go ahead. I have got about 60 posts in Manipur, company level, sub-company level, like that. So I said, I'm going to take them away from here and put them somewhere else for training. So he said, but how can you do that? I said, why can't I do that? Because if we are to involve ourselves in counterinsurgency operations or in counterterrorism, I cannot have my men without a legal cover. You have to accept this fact. You cannot ask anyone, which includes a soldier, to do something deliberately for which he is not covered legally. So I said, I will remove that. He says, you can't do that. I said, I'm sorry. I cannot have my officers coming to me and say, I won't do it. You can imagine the discipline and morale of the people if you say that, look, I'm taking away your legal cover, go and do it now. Some people will come to me and he will say. So I explained to him the whole issue. And unfortunately, because of the conditions, because the Disturbed Area Act and all that, which has been continuing in Manipur, that AFSPA has not been lifted till today. So please, for heaven's sake, don't blame the armed forces. Not even blame the AFSPA. You have to blame the people who are unable to lift that disturbed area act from those areas. So yes, over the years, perhaps you want to review that law. Certainly it should be done. You can look into those parts of the act, particularly, I think, Section 3 and Section 4 of that, if I remember correctly. Those are the ones. So you can review that. Instead of making an NCO responsible, you can now raise it at a higher level. Definitely, you can change the name, whatever you. But you cannot, if you want to employ any service officer or man in such duties, you cannot not provide him a legal cover. Otherwise, you will have cases of indiscipline in the armed forces, in the army. People will come and tell their superior officer, I will not do it. The men will say, I will not do it. So I thought I must make my position clear. And that is how I have nothing against the OPSA review. You can do it because of the new conditions that are there. But please do not employ the soldiers without a proper legal cover. Thank you.
Thank you, General Malik, for your very honest opinion on this. But I think we'll have to move forward. Yeah. And no, that's okay. This is also necessary because you see, a debate always has two sides. There cannot be only one side to a debate. So we are not going to the other side of the debate today. We can use that on some other occasion. So, General Bali, please, let's take it forward.
Thank you.
I think we have the international panelists also waiting.
Right. Thank you very much, sir. Thank you for your views. My question is to Dr. Pascal Levesque. Yes, there you are. Now, in the Jonaru decision of the Supreme Court of Canada, this was a landmark to ensure the independence in the military justice system. Do you think it has gone far enough, or do you think there's still scope of improvement in the Canadian military justice system? So can you explain the Jonaru case or decision?
Well, there's always room for improvement. The path towards judicial independence within the military justice system started with the General case, with the case of General in 1992. And while the case was before the Supreme Court of Canada, the military justice system already evolved so that the court was cognizant, acknowledged the effort at that time. But after that, well, there was a reform 6 years later in 1998, 99. And then, but yet, there was still room for improvement. I'll share with you a story of mine. I was a defense counsel, paid by the Forces Defense Council. And while wearing the uniform, one of my first case, I realized that, oh, the military judge is on renewable term. So he's on a 5-year term. He's not appointment until he's not appointed until retirement. And uh, coming from a civilian background, because I joined the forces late in the game, and I was a defense counsel prior joining the forces. I look at that and I said, on appearance, the judge might be a reasonable person. Having look at the system, might say, well, the judge might be inclined to favor the crown because he wants to be reappointed. So argue the motion. Well, of course, you could suspect that some of my colleagues, looking at me wearing the uniform, raising a motion that saying, well, Your Honor, don't take it personally, and with respect, but I think you're not independent. The judge smiled at me and he said, well, that's an interesting point of view. Ultimately, he fixed the act to a certain point, and then later down the road, there was other case law by other colleagues that in 2006 they decided to amend the act after a court-martial appeal court decision in the case of Leblanc, where they appointed judge until retirement, until the compulsory retirement age in the Canadian Forces, which is 60 years of age. So there's always room for improvement. Today, there's a debate about, do military judges needs to be civilian or still military? Do they need to be judges like any federal court judges in Canada, or they still need to have a uniform, or should be associated to a certain point with the military justice system or the military organization? Do they still need to have a rank? Because well, what if a judge on the street, a military judge on the street, has to pass by a general? Does he have to salute the general? I think this debate, it's a bit of a red herring. I'm saying that with respect. I think what is critical is are two essential elements for a military court system to work effectively. You need to have judges that have the expertise and who they know the culture. You could achieve that by having a civilian judges. Technically speaking, you could achieve that to having a civilian judges who have that expertise because he's trained after he's appointed, or because he had some experience previously, or you could have full military judges as we have today. The second point is portability. Whatever system, if the military judge is a civilian or not, you have to think of your system as, okay, we could be involved in a major, and I wish it would never happen, but we never know. But we have to be ready to be involved on a very short notice in a very large scale conflict abroad. So you need to have a system where you could pick your judge and bring him with you over in whichever country. Now we have, because of the pandemic, and literally we could see that today. We have the technical means, but you never know when the judge would say, you know what, in this case, because there's a victim of sexual assault, I would like to be on site to hear the witness. So you have to think about that when you design your system, whichever you appoint. I think the nomenclature of having a judge with a rank, no rank, uniform, not uniform within the system, as long as the third one, well, I would add to one, The two other essential elements, impartiality and independence. So if you have portability, expertise, impartiality, and independence, those are the core, I would say, elements to have an effective military justice court.
Thank you, Dr. Pascal. Thank you for once again highlighting this issue, which seems to be universal. Should this be handled by the military? Should it be handled by the civilians? I think it resonates with a lot of people. It definitely resonated with my co-panelist here, who brought up a similar point about the FTs. My next question is to Judge Maya Heller from Israel. And I would encourage everyone sitting here to read those two chapters, which one written by her back to back and one written by Professor Amos Guerra, about a fantastic case of a soldier, of a sergeant, and how much chaos it created in Israel, and how still a court headed by Judge Heller did a stellar job of remaining independence. So while you could talk about how you managed to withstand all that pressure and still remain independent, but the question I really want to ask you is what I asked Professor Amos the other day, and I'll rephrase it for you. At the end of that case, what are the most important lessons on independence that you would like to impart to JAG officers or military judges?
Okay. Good afternoon. Thank you for having me here. I have to say that at first, when Professor Giora was talking to me about this case and about the book and the project, I hesitated, and I told him that I have to think about answering his questions, or we didn't even think that I will write something at that time. And I hesitated because, as you know, judges usually do not speak about the ruling, their sentencing, and everything they have to say is they put inside this ruling and the sentencing, and they do not speak about it later on. But I think when I thought about it a bit later, and because I thought that it is very important to emphasize our judicial independence system, it was important for me to join this project and to write about my personal reflections. And so others would be able to see a bit of what was happening, not inside the court room, but more generally. And even today, a few years after this case, people keep asking me if we didn't have too much pressure that influenced our judgment. So having that, I've decided to join this project and to write my essay. So thank you for having me here, including my essay inside the book. And it is important for me to say that, as I said in this essay, that I really believe. First, I'll say that there's this phrase that you cannot a minute to convince the convinced, right? But I do believe that it was important to write those things that it might change few ideas of people that read it, not only in Israel, but worldwide. So as I wrote, this case, for the first time in many, many years, created a big riot, a big chaos in the Israeli public opinion, because from the beginning, when the Sergeant Tazaria was arrested. Important people, even politicians, had something to say about it. Some of them wanted him to be pardoned before being indictment. Some of them said that, I don't know if you know, but in Israel, military is compulsory for all men and women when they get to the age of 18. So everyone have someone in the army, their own children, friends' children, families' children, because everyone at the age of 18 is joining the army, compulsory for a few years, and then he can decide if he's finishing with the army, he wants to make it a professional service. But most Israelis have someone in the army, so when a young soldier was indicted in a manslaughter, in this case, many people thought, well, it could have happened to my kid, and I know someone that it could have happened to him, and the public opinion was, everyone was trying to say his opinion about this case, simple people and politicians as well. But what was very important for us is really to separate ourselves from the noise outside the courtroom, physically outside the courtroom and in the media. And I think we really implemented this judicial independence in this court specifically. And as it was said before, and you read some of the paragraphs from the ruling and the sentencing. We really prefer everything we heard about in the courtroom, and we separate ourselves completely from what was outside. It's hard to explain it for someone that was not in this position, but reading the ruling, you can see it was based merely on the facts and that we heard, the evidence. Nothing came from the outside. So I really think we did it as we should have done it. If you want me to give specific examples, I can do it.
You could talk about the threat to your life. I mean, you even went jogging with guards and so on and so forth. Just talk about that a little bit.
I have to say, as I wrote in the essay, maybe I was naive, but I didn't really think that something could happen to me. But I listened to the professional people that are dealing with the security and telling me that it's enough to have one person that will hear what was said before and in the outside and try to do something to me. So unfortunately, I had someone that guarded me 24/7 for 9 days since the day of the ruling and forward. And but I really didn't think that something would happen to me personally, but I know that in the media, I knew that people wrote really not nice thing about me. They compared me to, I don't know if you heard, a radical left-wing person by the name of Tali Fahima that helped Palestinians, terrorists, and even was sentenced because of that. And I had pictures of me with the Hitler's mustache in the newspapers and in the media. public media networks. But at that time, I really tried not to look at anything regarding the media networks. I didn't have Facebook or Instagram at all. I went out of the groups in WhatsApp because I wanted people to be able to speak fluently and without thinking, what is she thinking about it? And I didn't want to be influenced about things that people wrote. So I know that I had someone to watch me, but I do believe that it was something that meant to calm me, not really to save me from something. Okay, do you understand what I'm saying? Anyway, even though I had someone to guard me, the important thing is that I understood that it was part of the general atmosphere in Israel, but really it couldn't affect anything that I thought. Actually, me and my friends to the bench, and because we were very made sure that we will be based only on the evidence of this case, and that's what we did.
Thank you very much, Judge Heller. You are a true hero. Now,
I don't feel like a true hero, I have to say.
well, we do, as I mentioned to you when we connected earlier. So it's a testimony to the riveting and the interesting contribution of the panelists that we have far exceeded the time. But still, if there are any questions coming from the audience, please feel free to ask.
So the floor is open to the questions from the audience, and you can address them to our editors, our moderators, our panelists, anybody you like. And I'd request my colleagues to please also pass on the portable mics to whoever wants to ask a question.
No, only to one of the moderators.
Anybody willing to ask a question? Can we have a
Judge Heller? No.
In the chapter, she's proud of it.
No, she's. If you read the chapter, she's not. Yeah. So you can ask her if you want to, but I can tell you that she's been committed, very proud. No, she didn't regret this at all.
Hi, my name is Arjun. I'm actually a lawyer here. I don't do military law at all. And my question is for Judge Heller. Looking back, do you think you would ever regret your decision or reconsider it on a personal level, not as a judge?
What do you mean as a person, on a personal level?
If you weren't
I
the judge,
judge him as a judge, not in personal level.
If you weren't a judge and you were an outsider, would your view have been something different?
I truly believe that the answer is no, because only being a judge in this case, you could know all the evidence, you can read all the papers, you heard all the witnesses, you heard all the claims, all the allegations. So people from outside that had an opinion, most of them didn't even read or heard all the things that came in front of us. So knowing everything that I know based on the evidence, I truly say that our ruling was correct. I really didn't think that we could have gotten to a different decision. And most of the people that have claims against the ruling didn't even read the ruling. So not only didn't read the evidence or everything that the paper and things that we got, that didn't even read the ruling. So I think it's important before you criticize something to know the facts. And so my answer is no.
You did come across as someone with great conviction, even when you were speaking. Thanks.
We ready for the next question? Right there.
Well, my question would be coming from a personal experience. Like recently, I was a part of a defense in a general force court trial. So I'll be asking about, there are more than 12 paramilitary forces. If Armed Forces Tribunal is 25-year-old, then I think paramilitary, as far as Justice Part is concerned, are 40 years behind the trail. So when I was dealing with that trial, so just bear with me if I'm just taking a bit of time. When I was dealing with that trial, apart from my legal journey or the battle to the trial, half of my energy was on to explaining to them you're not a part of a force when you are dealing with this case. You are saying it as a judge or to have justice, and you're not an agent of the force. It sort of was a quandary for me, that how to explain or to take them to the level that you're here for the justice only, to do justice and not to represent the force. So as far as paramilitaries are concerned, how the growth of law has been there in our country, so a take on that, and within the purview of the effectiveness of tribunals, basically. Now, Justice Bhala is there, who knows how tribunal functions. They are at the mercy of state funding at the end for small things, for small infrastructure setup. And there has been an occasion when AFT didn't function for a very long time. A writ petition was filed by Mr. Navdeep Singh.
Can
there
I
only.
just interrupt you?
So I'm done.
Don't make the statements. Ask the questions.
So my question is, I'm saying within. So my question is with regard to this tribunal and how it has been functioning in our country, and especially when it comes to the paramilitary justice for the paramilitary forces. What would be the take?
Say, Harish, as far as the tribunalization is concerned, you only have to read the judgment of the Honorable Supreme Court and Madras Bar Association. Series of judgments, you'll get to know what are the problems we are facing and how the Supreme Court is trying to address them. There is still resistance by the official establishment, but we are getting there, as Professor Shriti Bedi also informed, that there have been many landmark observations and directions by the Supreme Court, and we will surely get there. As far as paramilitary, we call them the Central Armed Police Forces now. As far as the Central Armed Police Forces are concerned, there's no tribunal, but you can approach the High Court for relief. So the law, their service acts, the BSF Act, IDBP Act, etc., they're almost pari materia to what the Army Act is, except the CRPF. The CRPF is modeled differently. And if you want to challenge any decision of any verdict of a court-martial or a force court, as they say, you have to go to the High Court. And the problem therein is that the evidence cannot be minutely examined, because you go in a writ petition and you do not go under the appellate process. You go under a writ petition, but there is no tribunal. And for more on CAPFs, Mr. Rajiv Anand is there. You can meet him and you can ask him his views about it. But
I wasn't like, these remedies were already there. I am more about how the growth of the trajectory.
The growth, the trajectory is absolutely the same as the army, because whatever progress we have made in military law is also because of the intervention of the high courts and the Supreme Court, and now in certain cases the tribunal. So the growth of military law in India is not inborn, or it has not come out of the system itself, but it has come out from a danda of the constitutional courts, basically. So the same principles apply to the Central Armed Police Forces also, because those are similar and parallel sections that they have, and these need to be interpreted in a similar manner. For example, that the judge advocate has to be of this rank, etc., and all other issues of independence. So it's the trajectory of law has to be the same, because those are material provisions interpreted in a particular manner. In case of the army, the same logic applies to the CAPFs also.
Any more questions?
Good evening. My question is to Justice Bhala. Sir, you had made a point whether the left to the AFT is sufficient or not. From whatever little I know of this act, the statute as the first and the last court. As a very
one tribunal, so I'll be guilty as charged. I hold a view that tribunals are a trivialization of justice. And this is my personal view. I don't make any value judgment on anybody or anything. But at the same time, at least we are getting there. If you read PPS Bedi's judgment, the Supreme Court issued directions for an appellate forum but dismissed the writ petition. It did not grant justice to that person. It said we should have granted justice, but in view of the fact that there is no appellate forum, and in the exercise of our power under the Constitution, we cannot grant you relief by re-examining the evidence, etc., which we all of us as judges are guilty of taking out all sorts of legal principles and to justify our decisions. But still, it took so many years for Parliament to be nudged into having an armed forces tribunal. Well, the efficacy of the tribunal will be judged. In my opinion, a judicial system is judged not by the judges, but by the consumers of justice. So all the judges sitting here, say on that side of the podium, are the ones who judge, and the persons who consume the justice system are the ones who judge the efficacy of a system. Unfortunately, we have a system where it is very, everything is, say, either by the government or the judges, and the people, which is actually the best common factor, get left behind. So sorry, this is sounding like a lecture, no, more than an answer, but at least we are getting there. The question is, we are questioning things are being questioned. I belong to that generation of lawyers, and I remember it very clearly. Justice P.C. Jain, who was eventually a Chief Justice, would anybody with the Army Act would just get up and say, Army, disciplined force, sorry. That was the order that is to be passed, and this will be one word written, dismissed. So look at where we've traveled today. We've traveled to a situation where lots of questions are being asked of the armed forces. And yes, you're right. I think people in the JAG branch need to understand that they do not represent, when the case is going on, they do not represent the army. They are there to get justice done. You're right. Thank you.
I am Justice Tahir, and presiding over this very AFT for the last about 4.5 years. I am not understanding as to what is the use of using the military word before justice. Justice is justice. It can't be qualified by any word. The title of the book is March to Justice. It is not the march to military justice. the fundamental and basics of justice, everybody knows that it should be fair, without any bias. No one can be a judge of his own cause. Adi altern partem, principle of natural justice. If military court or court martial is trying someone, तो मैं नहीं समझ पा रहा हूं कि मिलिट्री जस्टिस अलग होगा और सिविल जस्टिस अलग होगा. When we are trying a person or an accused under section 69, that is section 302, can the ingredient of section 302 not be seen by the court martial? And we are hearing the appeal. क्या हम उसको नहीं देखेंगे? तो justice is justice, and basic principle of justice is available everywhere. There can be no distinction that is civil justice or military justice. So far as Madam doubt is concerned, that tribunals are not working fairly or working under some pressure, this notion is quite wrong. When we deal a case, we know it well that our judgment will be appealed to the Supreme Court. And आज तक मैंने कोई ऐसा नहीं देखा कि किसी मिनिस्ट्री ऑफ डिफेंस से कोई ऐसा कोई इंटरफेरेंस आया हो. इस 4.5 साल के अंदर मेरे नोटिस में अभी तक कोई ऐसी बात नहीं आई कि मिनिस्ट्री ऑफ डिफेंस ने कोई इसमें जो है दखल देने की कोशिश की होगी या मिलिट्री अथॉरिटीज ने कोई दखल देने की कोशिश की हो. तो बस इतना ही कहना चाहता था कि वी आर कंफ्यूजिंग अबाउट मिलिट्री जस्टिस और सिविल जस्टिस. जस्टिस इज जस्टिस एंड द टाइटल that march to justice, only march to justice. Thank you.
So I think we have just one last question.
Yeah. My name is Vice Admiral Bisht. I am the administrative member in the AFT, along with Justice Tahir and Justice Chaudhary. Professor Bedi made a mention about administrative member in particular, and it gave me a feeling that probably there was some derogation in that the administrative member is not law qualified. But it is an act by Parliament. AFT Act has been passed by the Parliament, and the aim or the reason behind appointing a senior defense officer as the administrative member is to infuse that little sense of the value system, the ethos which underlies the functioning of the armed forces. As Mr. Pascal mentioned, that there's a work culture in the armed forces. And General Malik has been army chief during Kargil war. He highlighted the point that armed forces function on the basic principle of discipline. And because of the basic principle of discipline, the work culture is slightly different than how a civilian organization functions. So that administrative member, he may be from any service. I mean, I'm from the Navy, and most cases, 99% cases are Army. But it doesn't take much to understand the work culture of the other service, because all services work under similar work ethos. So I think the other point which Justice Tahir has already mentioned, that the functionality of AFT is very fair, and most actually 90% of the cases are the verdict is given in favor of the petitioners generally. So I can only highlight the point which he mentioned, that the AFTs have come of age to a large extent. It is a different point that a large number of them have not been, members have not been appointed. So a large number of AFTs are not functioning because of lack of quorum, lack of members. But from Preetpal Singh Bedi to AFT is a significant journey, and it is, I think, a lot of success has been achieved in that. Thank you.
So I'll just point out that Professor Bedi was not just talking of the AFT, she was talking of the concept of administrative members in tribunalization as mentioned in the judgment, as mentioned in PPS Bedi, when it talks about administrative members, and administrative members are there in other tribunals also, CAT, etc. So she was giving a backdrop of what the Supreme Court has said. She did not mean that administrative members are not doing a good job. She was saying,
I wish we have more
Yes.
people like you in the tribunals.
Yes.
So there's nothing personal, and I would like to clarify here that in Colonel PPS Bedi's case, like Major Nadeep has pointed out, they had specifically spoken of an independent judicial forum for appeal, which obviously meant that no member of the forces. So that is the connection and the reference that
And I went to him 2-3 times when we were discussing this matter, whole issue. And the law was passed. I had retired by then, but I was a member of the National Security Advisory Board. And a couple of times I was called by the Parliament people also, the Defense Committee, to give my opinion and all. And there is no doubt in my mind that our AFTs have come a long way. And, you know, one is very happy and satisfied with the kind of judgments which have been. Sometimes I feel sad that some of the judgments which have been passed are not being followed up with the Ministry of Defense. There are a number of cases, and that saddens us, that despite the judicial decisions being given by the AFTs, why the Ministry of Defense is not following up. So as far as the administrative member is concerned, although Admiral Bisht has given his opinion, and rightly so, but when we were discussing this matter, at that time also, we had these cases of Manipur and Nagaland, before us. And we all felt that when, let's say, you ask a platoon to go and raid a particular house in a village somewhere. Now, the platoon has gone into the village. They have carried out that whole action as per the army drill which is taught. And then you find that while you have killed a hostile, and you may also, happen to kill an innocent person alongside. You don't know who's who at that time. That is the kind of. So who is then going to give an expert opinion, if I can use that word? While what Admiral Bisht has said, quite rightly, that we have our own ethos, our own traditions. Well, traditions are not so important, but our value system, our training, etc., all these things. But what is more important is to help the judges to make them understand that how this particular such actions take place in such cases that we were discussing under OFSPA and others. That is how then the government also agreed on having an administrative member of the AFTs and all. But I have to say that that our AFTs have come a long way, and there is much appreciation, if I can use that, amongst the serving as well as the ex-servicemen about the justice that has been given. The only thing, as I said, is that I don't know why they have not, they are not having adequate number of AFTs, which is what is lacking today, unfortunately. And also why some of the decisions which have been given are not being followed up. Thank you.
Ladies and gentlemen, it has been a scintillating evening thus far. On behalf of Blue One Inc., I'd like to thank all our distinguished guests and participants for their gracious presence and time. And now that your grey cells have been adequately stimulated, what can be better than some more piping hot stimulants served with delicious snacks? As you join us in the foyer, we would like to announce that the book is available at a special price for those who might want to pick a copy. Thank you once again.